Do you hear the Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan? All persons having business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Good morning, and welcome to the court's April oral arguments. For those of you advocates who have not been here recently or ever, I'd just like to remind you that rest assured that every member of this court has read your briefs. We are an inquisitive court, so much so that we have reserved 5 minutes of free time so that the advocates in the calendar cases can make their presentation of arguments without interruption by the court. Let me suggest to you, therefore, that you use those first 5 minutes to outline your outcome determinative issues and not waste time reminding us of what you put in your briefs. So with that, we'll call the first case, which is Bitterman versus Bolf.
Good morning, Your Honors. Philip Ellison, appearing on behalf of the appellant. May it please the court. Your Honors, today the issue before you is one involving what is a public official. And it's the word public official is the word that appears in the statute as applied by the legislature. And this court has explained courts may not speculate regarding legislative intent beyond the words expressed in that statute. And here, a public official who intentionally violates this act, the Open Meetings Act, shall be personally liable. This court has explained repeatedly that when a phrase is not defined by the legislature, we apply its plain, ordinary meaning, and we can use a dictionary definition to apply that ordinary meaning. And here, as I've cited a couple different dictionaries, but the sum and substance of those dictionary definitions makes a public official one who holds or is invested with a public office, a person elected or appointed to carry out some portion of a government's sovereign powers. If the legislature had meant to make a more narrow definition or a more broad definition to a public official, it could have defined it in the definition sections of the Act. Here it didn't do so. So the conclusion here, I think, is that the Court of Appeals erred by applying a definition which is unordinary and not the plain definition as provided by the dictionary. The problem I see for the appellee's case is that they're trying to combine two elements together into one element. There's three elements for an Open Meetings Act claim under Section 13. You must be a public official, you must have violated the Act, and you must have done so with the requisite intent. Here the issue is the solely before you is what is a public official. Whether or not that public official breached their duty under the Open Meetings Act goes to element 2, whether or not there was a violation of the Open Meetings Act by that public official. So outside of the issue of the fact of what is a public official and whether they violated as two separate and distinct...
Counsel, good morning. Just a question for you. You know, deciding what a public official is, I mean, isn't this what a clerk's job is ultimately to do? I mean, isn't this ultimately the main responsibility of a clerk?
That is correct. And not only by tradition or by appointment, but rather in this case by law. The General Law Village Act specifically prescribes that the public body fulfills its duties by the clerk, in this case the clerk of the village, who is an elected position.
I'm sorry, is that in the Open Meetings Act?
That is in the General Law Village Act, is the clerks who fulfills the obligation under the Open Meetings Act.
Where does it say that in the General Law Village Act? What section are you
It's MCL 64.5, and it's subsections 1 and 3.
But it references the Open Meetings Act, you're saying? The text of that statute references
it? Does not specifically reference it. The problem here is that an Open Meetings Act is a general applicability statute that applies to all sorts of government structures, whether it's a village, a township, a county government, a state government division. Different people have different titles in different parts of their relative boards that they serve on.
But one thing is apparent in the Open Meetings Act, the obligation to prepare and post minutes is exclusively a board responsibility, is it not?
preparation for open meeting minutes, under the closed meeting minutes, that would be the clerk specifically in
Where are you looking in the open meetings?
MCL 15.267, I believe it's subsection 2.
But it doesn't say the clerk of the village, it says the clerk of the body.
Of the body, correct.
So what do we make of that?
Where we make it up is that a public body, and I believe the Michigan Press Association's brief, I think, does an excellent job addressing this, which is that we need not substitute responsibility for structure. And here, the responsibility of the public official, who is the public official that's responsible for making the meeting minutes that are required under the Open Meetings Act? Here, in this particular...
It's not specified in the general part.
Well, but the General Law Village Act provides that.
You may prevail somewhere else. I'm actually focused here on what the Open Meetings Act requires and what the definitions are that are focused there. What the village chooses, how the village chooses to populate the, to facilitate its businesses is, I think, irrelevant to this inquiry. So I'm really trying to figure out, you open this subject matter up saying that the village assigns the clerk to do the minutes of village meetings, but that's not what the Open Meetings Act requires.
The problem, though, is that while the statute addresses public bodies, a public body is not a person. The public body is not an entity.
But only the public body, and not persons extraneous to that public body, are responsible for minutes, as I read the Act.
It says each public body shall keep minutes of each meeting.
Correct.
So
she's not a member of that public body, is she?
Well, I would argue that she is. Under the General Law Village Act, she is the clerk of that council, and is the one required to, so she is fulfilling duties that are required of that body.
So absent the ordinance you're referring to, she would not be.
I would disagree with, I think that's too narrow of an approach here. Well, the question is what...
No, just hang on a minute.
Sure.
Assume that I agree with you that public official is somebody who's invested with office, elected or appointed. All right, so then the question is, how is that public official a member of the body? Here.
Again, I think that's, with all due respect, I think that's an incorrect analysis to come from. I think the issue is, step one would be to inquire, is the person a public official? Okay.
We're there.
Okay.
I've said, for the purpose of my question, you and I agree that the definition of public official is one who is elected or appointed to an office, all right?
Correct.
She is elected or appointed to the office of clerk, correct?
Correct.
All right. Now my question is, but she's not a member of the public body, correct?
Correct.
So, don't you, even if you win here, don't you lose?
I don't think so. The issue that's before you today, it was conceded in the record below, or at least not challenged, that Cheryl Bolf committed a violation of the Open Meetings Act. That issue has not been before you. The issue today is, and again, I think this goes to the top of...
My point is, if the law requires the body to do something, persons external to it, I mean, I don't think this clerk has any authority to approve minutes on her own or do anything else until the body itself does that, correct?
The body itself would be responsible for...
She couldn't say, I'm sorry, that's not the way I see these minutes, I'm not putting that in the minutes, right?
If she did that, she would be a public official who would be in violation of the Open Meetings Act at that point then.
In what way? She doesn't control the minutes, right?
Well, wouldn't that, in my estimation, that analysis that you're suggesting, or that line of inquiry, would go to element 2, which would be whether there was a viation of the Open Meetings, not whether it's a public official or not.
Let's say, no, I'm trying to figure out who can make a violation at this point.
Well, I guess my argument I would put to you is that we have to look to the words of the legislature as put forth here. The legislature didn't say all members of a public body shall not, who intentionally violate.
So let me take this slightly different direction, or one step removed. What about a publicly elected dog catcher? Publicly elected, they have duties to catch dogs, and under the definition of, does this person hold office, that person is a public official. is that person a public official for purposes of the Open Meetings Act?
I believe they would be. Under element 1, the first thing that needs to be resolved is, are you a public official? If the dog catcher then did not commit a violation.
Barack Obama, he's a public official, a federal public official.
He's a federal public official.
For purposes of the Michigan Open Meetings Act.
That's correct, because the legislature is provided the plain, ordinary definition of a public official. The question is, but that goes to element 2, when you talk about a dog catcher, element 2 would be, did that dog catcher commit a violation of the Open Meetings Act?
But if the dog catcher shows up at a meeting and blocks the door, then your view is misdemeanor.
For example, if that dog catcher was having his employee evaluation and the notice was put up.
No, it's totally irrelevant meeting. The dog catcher just was like in a bad mood and he saw a public meeting happening and he wanted to block some people.
Correct. If he was intentionally trying to violate the act, he would be in violation.
Wait a minute. So the dog catcher would be, but the dog catcher's brother comes with him. The dog catcher's brothers never hold an elected office ever. And the dog catcher's brother and the dog catcher go to the open meeting and they stand in the doorway. Nobody comes to this meeting. But the meeting has nothing to do with dogs. The dog catcher is a public official and therefore liable, and his brother is not.
That's what the legislature has prescribed under Section 13.1.
Well, wouldn't it make more sense to say you have to be a public official for purposes of the Open Meetings Act?
But that's not what the statute says. And that's, I guess, the basis I would point to this court to is that this court has said over and over again, we look to the plain language of the statute.
Well, isn't it you're right. Of course we look to the plain language, but there's lots of plain language here. Isn't it your duty to basically try to show that public body and public officials are both terms that ought to be given their plain language meaning, and that they can each be given their plain language meaning in some harmonious manner? In other words, that the actions of even non-public body persons have the potential to affect the duties of the public body. You haven't done that here. But I think that maybe that would be a useful direction to go, to show that, in fact, there are ways that non-members of the public body, their actions, and I think this is what Justice Larson was broaching, do have the potential to affect the works of the public body.
In that instance, if they're a public official, the legislature has prescribed a penalty. If they're not a public official, the legislature has not prescribed a penalty. That may be a place the legislature needs to address in the future, but that's not what's in the language of the statute.
Isn't it possible to reconcile it, if you think of public officials as people actually having some duties and responsibilities under this act, to say that that responsibility is the responsibility of the public body, not to conduct its meeting and not to take votes if the dog catcher and his brother are blocking the door, or if the notice wasn't given by the designated person, and so forth. Wouldn't that be a much more efficient way to make sure that we have openness and transparency in all of our public meetings in Michigan? Or does it make more sense to say that if President Obama blocks the door, that that's a violation, but if, for example, a police sergeant blocks the door and doesn't allow someone who's opposed to a pay increase to come into the meeting, that's not a violation?
It would be, except that's not what the legislature did here. The legislature has made it the duty of all public officials, not just members of the board, not only certain public officials. It has said a public official who it didn't limit that in any way. And so if we apply the plain ordinary definition here, it applies to everyone who is a public official.
You keep going back to that, but don't we also, and I agree with you, we have to look at the plain language, and a lot of times it's appropriate to look at a dictionary definition, but sometimes we also have to read the term in context. And if we take it and read it in a vacuum, as you're suggesting, sort of divorce it from the act, it leads to these kind of unusual outcomes that are being discussed. So tell me why we shouldn't read it in the context of the act in which the term is used.
The problem that I see is if we adopt that definition as in that suggestion of we put a nexus between the act and the duty under the Open Meetings Act, what that would permit is a situation like this where a clerk has gone in after the fact to hide the actions of the public body, and there's no penalty here for that. There's no prescribed penalty for that clerk for altering.
The public body is responsible for its minutes, is it not?
The public body would be responsible, but if we adopt the definition that we're discussing, that a public official is only those who have a duty under the act, there's nowhere in there where there's no other duty of any other.
If you want to reserve any time, now's the time.
Under your theory, I just want to press the point. Under your theory, there's no penalties for anyone else in the world who's not a public official. But you're not concerned about the other 99.9% of the people out there, just the few that are public officials violating the act?
That's correct, because that's what the legislature has prescribed here.
So you can't read these, you can't conceive of any way to read these terms in a harmonious fashion so that all are given their plain meaning definitions in some reasonable way.
I can, and I think the answer
Do you want to make an effort to do that?
the effort here is that step one of the analysis is are you a public official? If you're not a public official, you can't violate Section 13. If you are a public official, you go to step two. Did that public official violate the Open Meetings Act? If they didn't violate some duty that they had, they didn't violate the Open Meetings Act.
My only problem is there is no obligation specified in the section regarding minutes that places the duty on in any other entity than the public body of which the clerk is not a member, right?
So I think what the Chief Justice is trying to get at is, so say we agree with you on step one, don't you lose on step two?
But respectfully, that's not the issue that's before you here today. That issue is not specifically here, and that issue has not been litigated below as to whether or not it was conceded by, I guess, not challenged below that Cheryl Bolf did, in fact, violate the Open Meetings Act. The issue here is she a public official or is she not? And I believe, based on the plain language, she is that public official. I know I've asked some questions. I do have co-counsel here who is here to argue on behalf of the Michigan.
I'm sorry.
The appellee actually addressed the second point. And I'll give you credit. That's the most concise brief I've ever read in this court. You did actually address what we asked you to address.
Thank you.
But on that second point, is there something more you'd want to say? Do we need additional briefing if we're intrigued by that second point? Appellee did put that, I think, with Section D in their brief. Do you want to file a supplemental brief if we're going to look at that point?
If you're going to look at that point, I would ask for that point. But that was
something more than what you have in the application response.
That's correct. And the reason being is that this court, by its November 25th order, limited the issue solely to what is a public official. And I hope today I've come across with the idea that public official is simply step one of the element before we get to whether there is a duty violation as step two or element two of a Section 13 claim.
Thank you.
Thank you.
I'm sorry, there is no more time.
May it please the Court, Mary Massaran on behalf of the defendant appellee Cheryl Bolf. In our view, the Court of Appeals correctly held that a village clerk who is not a member of a public body cannot be held liable under 15273, and we would urge a peremptory affirmance. There are numerous reasons, many of which have been included in the brief. I'd like to focus on three this morning. First, the phrase public official, when read within the context of the statute, does not properly include a village clerk who's not a member of the public body. And the language in the civil and criminal liability provisions, both in the Act, only provide liability for those who intentionally violate this Act. Consequently, attempting to import portions of other statutes, such as here, the General Village Liability Act, is expressly excluded by that phrase. And if the court were to ignore that phrase, it would be violating all those rules of statutory interpretation that say you can't interpret language so that it's a nullity. If there were any ambiguity, the doctrine of avoiding an interpretation that might render a provision unconstitutional and the rule of lenity would come into play, because the obligations at issue here are, as the questions have illustrated earlier, obligations that are imposed on the public body, and therefore a non-member of that public body who has no control over the openness of the meeting, the posting of the notices of the meeting, the approval of the minutes of the meeting, cannot be constitutionally held liable for some violation of that statute. I think it's helpful to walk through the statutory text. And I know the court has already done this, so
Counsel,
I don't want to
good morning. I just want to go back to this, and I understand the argument that you've been making. And first off, it's great to have you with us today. But the question I have is that when we're talking about a public body, isn't this the ultimate goal and objective of a clerk, is to preserve the integrity of the public body? So doesn't a clerk, in a lot of ways, get held to a higher standard?
I would agree that the clerk has a role in maintaining records. That's a very important role.
But they're elected for that exact purpose, are they not? Like, if I'm electing a clerk to serve as a public official, isn't that the reason that that person is ultimately seeking that position and seeking that office?
But what the legislature, I think, was trying to do with the Open Meetings Act was to focus on a very particular problem in a very particular way. And the legislature's language in that statute, the longer you read it and study it, it seems to me, the more you see a certain brilliance in all of the pieces
But Counsel,
of it.
if I'm serving on a board and I'm part of this public body and I'm an elected official, in a lot of ways, as an elected public official, aren't I in fact relying on the clerk to make certain that everything is done correctly and to not hold the clerk responsible or accountable? Wouldn't that defeat my role, a job as a public official on this board and the board itself?
I don't believe that's so. I don't think that is anywhere in the language of the Open Meetings Act or in the other acts which create clerks, county clerks, village clerks, or other clerks. All of those acts put a certain role on the clerk. But what the legislature did here was say, we're going to impose on public bodies as a group and their members an obligation about notice, about records, about openness in their meetings. And we're going to hold them accountable for those requirements.
But even if I concede that that's true, I'm not sure how I get to when the legislature uses a pretty generic term, public official. I bet you could go out on the street and ask people what a public official was, and you get 9 out of 10 saying, well, somebody who holds public office. I mean, it's not so common a notion that I can't imagine that the term, the undefined public official, wouldn't carry its ordinary meaning. So I'm asking you, the Court of Appeals said, well, a public official is not just somebody who holds public office, it's somebody who is also a member of the body. And I don't see the connection. So maybe you can provide the connective tissue.
I think that...
And let me just say, it may be that a public official who is not a member of the public body cannot be responsible for the obligations of the public body, but that doesn't mean that they aren't a public official. So explain why they must be both.
I would say a couple things. First, in terms of this court's discussion about what does it mean to be a public official and the precise tasks that we're talking about here, the court has said it's a job that entails exercise of governmental authority and discretion. And certainly the court has in Friedland and People versus Cantu said an auditor, for example, may not be a public official because their work is mechanical. Here, what the legislature talked about was a duty, imposed it on the public body. The public officials who are members of that public body are the ones who are accountable.
But wait a minute. We're talking about the minutes.
Correct.
Obligation. But there's also another obligation to hold your meetings open to the public. If public official is defined in its common plain meaning that I've suggested, somebody who holds public office, do you really believe that if the mayor who objected to the topic that the public body was going to debate, and did a Governor George Wallace stand in the front door saying you may not enter, that he would not be violating the Open Meetings Act, open meeting provision?
If it is a city where the mayor is not a member of the council,
Not a member.
not a member of the public body,
He just is precluding the public from attending an open meeting of the public body.
that mayor could not, in my view, be held liable under this provision. And here's the reason why. Because this provision is speaking to the public body. And it is allowing, in its penalty provisions, various remedies against the public body, invalidating the action, imposing costs, and so forth. And it is going one step further in saying, If a public official is using a generic word, like the many employment statutes use the generic word employee.
But why didn't they say a member of the public body who intentionally violates the act?
They might have done
blah,
so,
blah,
and
blah.
it would have been clearer.
Easier.
It
Yeah.
would have been easier. I would definitely.
Why do we get to fill the gap then?
Because this court has said consistently that we read the provisions of a statute together,
Yeah, but
and that
there's
we
nothing-
try to
there's
harmonize
nothing
them.
necessarily incompatible about the legislature saying, we're going to make the zone of people who are in danger of liability public officials. And then we're going to impose duties on the public bodies. And the question then is whether the actions of non-public body members who happen to be officials can be a violation of the act if they can't effectuate the obligations that are statutorily imposed on the body. Why is that incompatible?
Let me try to answer it using the hypothetical from earlier. Only we'll use the mayor example. The mayor stands in the doorway. The mayor says, I'm not going to allow anybody in this meeting. Now, because the legislature holds the public body accountable for that openness, if the public body persists in its meeting, then the public body is properly held accountable. And we know from our democratic system there are going to be other consequences from that kind of action, particularly when the public body says, we're not going to continue, Mr. Mayor, unless you let people come in.
That's where I have a disconnect. Because what your argument is that you're going to hold the public body accountable, but the clerk, whose responsibility it is to actually serve in a capacity to make sure that it's open and transparent, would not be held accountable. So if I'm on a board and it's not done correctly, am I responsible for the actions and conduct of the clerk?
The clerk, first of all, in terms of...
Isn't the answer yes?
Pardon me?
First, isn't the answer to his question yes?
It
Well,
would,
isn't the
just
answer
based on your
actually-
hypothetical, right? Yeah.
Yes.
Isn't the answer actually, they're not responsible for the conduct of the clerk, they're responsible for their own conduct, and if they go forward with the meeting, now they violated the act.
That's exactly the answer. Thank you.
So when there's been a specific violation of the Open Meetings Act, everybody sitting around the table in that conference room is responsible except for the person who is most directly and proximately responsible for that specific violation.
It's the public body's obligation to ensure that openness and transparency.
Well,
And that is
you shake your head, but
precisely what the legislature...
You shake your head, but I, and I think Justice Bernstein, are accurately summarizing things, are we not? Everybody sitting around the table is responsible for the violation except for the public official who specifically was the proximate or the immediate cause of that violation.
If they proceed, absolutely, that's correct, because it is the public body that bears the responsibility that the legislature intended.
So I just want to make sure I understand your argument. So if I'm serving on a public board and basically the clerk doesn't do their job, the clerk is not responsible under your argument. And again, with Justice Markman's question, which is exactly what I've been focusing on, I just can't get past this idea that that is the entire purpose and reason why the clerk ultimately sought the position and sought office. They sought this position to do exactly what it is that you're arguing they should not be responsible for.
A couple of points contextually in response to that I think are important. First of all, if you look, for example, at the village clerk provisions, they talk about recording the proceedings and the ordinances and the resolutions, which is a particular function of governments. And they do not talk about the minutes under the Open Meetings Act. That is nowhere in the General Village Act.
But then why have a clerk then? Why would I run for clerk, or why would I be a clerk, or what is the reason for having a clerk if the clerk doesn't have any responsibilities?
The clerk has responsibilities to maintain a record of what legislation the legislative body has adopted under a separate statute.
So the clerk may have some liability under some other statute, or the clerk may not get reelected. Your view is simply that under the Open Meetings Act, it's not the clerk who bears the responsibility, it's the public body.
That's
but we can get at the clerk some other way.
Can I ask
Precisely.
this question? What about under 15.267 that specifically says these minutes shall be, this is closed meetings, these minutes shall be retained by the clerk of the public body. So the problem I'm having is, do you think that the clerk is a public official for purposes of 15.267, but not for purposes of the provision that's at issue here?
I have 3 points to make on that. I'm glad you asked that question. First, the provision, the easy answer in terms of the opinion in this case is that closed minutes are not at issue, and that provision isn't. It's not a very satisfactory answer, so I have 2 other answers. The second is the duty there of keeping minutes is imposed on the clerk of the body or the recording secretary of the body. Again, it is flowing from the body. It may or may not be a publicly elected village clerk, even in a village.
Could they designate, if I remember, could I designate my secretary to do the minutes?
You could. I think there's nothing in the Open Meetings Act that precludes that, and in fact, I think that language under the closed section I think it's very helpful to our position. And here's why. It's the only language in the Act that talks about anybody else doing anything. And it talks about somebody doing something in a very particular way. What are they doing? They are taking minutes of the closed session. And the minutes are only to be used in an enforcement action against the public body or a member of the public body. So I think what the legislature did was say, whoever the scribe or the recording secretary, the clerk who does this, we're going to have that person keep those minutes separately.
So what? I'm still having trouble with the connective tissue argument. If they happen to designate a public official to do that, it sounds like they're in the soup. If they choose a private clerical to do it, that person probably isn't. I'm still having trouble getting from the plain language of public official to the freight that the Court of Appeals poured into this, which is it's a public official who's a member of the body. I don't see that connective tissue, and so far, I don't think you supplied that to me.
The public official language is used in that enforcement provision, in my view, as a way of taking in, not the clerk or the scribe referenced in 267, but only those people who have the higher level
I know
of...
you say that. My question is, why should I believe or understand that to be legally required?
Two reasons. First, because the notion of public official encompasses this notion of exercising governmental power, discretionary power, and that is the nature of what the members of the public body are doing. It's not the nature of a mere scribe.
I don't mean, I apologize for interrupting, but the way you're talking about it, are you urging us that instead of looking at that term in terms of its ordinary usage, that we should consider public official as a term of art, as it's been defined in the Friedland case? Is that the position you're now taking?
I think that's one way to look at it. I'm not sure if it needs to be a term of art. I think harmonizing the provisions of the Public Meetings Act itself, which speaks repeatedly about the public body and which imposes obligations onto the public body exclusively with respect to these minutes, in order to give meaning to all of that language in those provisions, it seems to me the concept of official within the penalty provisions has to match. And in order to match it, it seems to me the concept has to be limited to the members of that public body that's at issue.
But counsel, I just want to ask you a question pragmatically. I want to ask a question pragmatically because I think we do have to look at the implications pragmatically. If I'm not able to find out information from the clerk and know it's accurate and hold them accountable and responsible under this act, how would I actually find out what took place at a meeting if I'm not able to have access to accurate minutes?
Other than your,
How would I even know? Like, how would I even know? I mean, that's the point. Like, how is it that I would even know what's taking place or happening at a meeting if you're not going to have these accurate minutes? Where would I even have the basis to know, understand, or appreciate that there could be issues as a concerned citizen that I want to even know about?
Certainly,
Just
that's the
pragmatically,
whole-
how would this
that's-
work?
That's the whole point of the act, and that is why the legislature imposed the obligation onto the public body as a whole. It's that body.
But how would I know there was a problem with the public body if I don't have a basis using minutes or notes that are represented by the clerk to even do an investigation into that?
You would have the minutes of the public body, the minutes the public body approved. You would have the right to be at the meetings of the public body.
But in the case at hand, they weren't aware of that the problem was that the minutes weren't accurate. That's the whole point. So how is it if I go to the minutes and everything seems fine because the minutes were amended at a later point, how would I even know to even begin an investigation to know what's happening within the public body? That's just pragmatically, how would this work?
Well, in this case,
pragmatically, we've run out of time. Thank you very much.
thank you.
Next case.